Good morning, happy Deepavali. See, this Deepavali is not only celebrated in India, it is being celebrated all over the world. Forget about that. But this Deepavali is not only uh, the memorable day of Naragasur's death, but it is memorable day for so many other events. Number one, when Golden Temple at Amritsar was inaugurated, that day was being celebrated on Deepavali, and therefore on every Deepavali, Golden Temple is being lightened colorfully. Then the Jain people and Buddhist, Mahavir, Jain as well as Gautam Buddha, seems to attain Nirvana on the day of Deepavali. And Lord Rama also coronated on the Deepavali day. So many celebrations are there for Deepavali. And particularly Gujarat, they commences their New Year account. These Marwadis and Gujaratis. These factors are there. However, today, since I have gone through a fantastic judgment, and I would like to refer the judgment for the uh, uh, candidates who are aspiring to be assistant public prosecutor and preparing for their examination. The reason is after going to the judgment, though the judgment is favorable to defense counsel, as a duty bound of assistant public prosecutors, you may get over these lacunas which are pointed out by the Supreme Court in this given case. This is AR 2024 Supreme Court 4201, and this is called Alar Kha Habib Memom etc. versus State of Gujarat. Alar Kha Habib Memom etc. versus State of Gujarat. This judgment would also help for the these additional public prosecutors who are holding tenure post, so that before filing charge sheet they could assist the prosecution police officer, investigating officers as to how to get over these lacunas upon which this judgment, the accused were allowed to go free by order of acquittal. See, actually, what had happened, there was some dispute while this water sharing, and there was threatened by the deceased. So, on the day, the accused, the aggrieved persons planned to murder the deceased. And when deceased along with somebody was refueled his vehicle, and these two accused seems to have attacked. Then what had happened? Conviction 302. Then court appeal was dismissed. The grounds which the Supreme Court has set aside the conviction. Number one, that the a police constable seems to have reached the police station after the occurrence, after the removal of the deceased to the hospital, along with the seized weapon. But unfortunately, his statement was not recorded, and his first information was not treated as FIR. But however, while giving evidence, that constable seems to have explained that when he reached the police station, somebody was there to give information. But that was not properly proved. Therefore, there was contradictions. The identification in the dock identification by police constable first time before the court is not admissible. Then what had happened? They say the complaint, the FIR, which was registered by the investigating officer, despite the fact that the constable has handed over the weapon, they say that FIR was post-investigation document. Kindly note down that this subsequent information being reached as FIR is called post-investigation document. Number one. Number two, the conviction was that the accused seems to have gave confession before the doctor. the Supreme Court says that confession is inadmissible because he is being produced by the police constable to treat his injuries. Therefore, that is unreliable, inadmissible. Then another factor, 27 recovery was, they say accused seems to have identified the place of incident, but factually, even prior to that 27 information, the police investigating officer know the place of incident. Therefore, that was also treated as inadmissible. Then the next question arises. They recovered articles, dress, blood-stained articles, were sent to forensic, but unfortunately, the Supreme Court says the request link evidence, that because the properties were sent to forensic not immediately but later on, and the police investigation or the prosecution failed to prove that there was further evidence linking the fact that these articles were remained in the same condition when it was seized till reaching the FSL, forensic laboratory. So on these grounds, the Supreme Court acquitted the appellant, and after going through the entire judgment, the additional public prosecutors may kindly work out what all are these lacunas and why they have. So I have some suggestion, but I cannot say that, as I cannot do harm to my profession. But if independently any public prosecutors or law graduates or any person wanted to know how to get over these lacunas, let us discuss about that in the interest of social interest. Best wishes.